to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we look at wills and probate. Now, sometimes someone will say, "Well, why do I need a will? I don't have that much in assets. I'm not married. I don't have kids." Well, number one, if someone doesn't have a will, state law determines who gets their assets, and the process to distribute assets becomes much more complicated. If someone has children, let's say a stranger determines who gets custody of the children if there's not a surviving parent, let's see. And usually, though, it creates problems and much added expense amongst the family. Now, people say, "Well, I'm not that old, I'm not planning on dying soon." Well, no one's planning on dying, but no one's planning on accidents also. We do personal injury work in my law office, and no one was planning on getting in that car accident either that injured them. So, someone has a will done. Typically, they can get a will done for less than $300. Most attorneys charge more than $300 an hour, so it's really one of the best bargains that you're going to get, because a good attorney is going to sit down with you, go over the process, let's say, explain what's needed, and how complicated is it? It's not that complicated at all. Our office emails someone a questionnaire. It's a couple pages long. They fill out their name, address, spouse. Let's see, who do they want as the executor? The executor is a person that will handle their estate. It's usually a spouse or a child who's close by. Who's going to be executor number two? We ask them generally, what real estate do they own? Let's say, is it in this state? Where is it at? And what are their other assets? Let's say in New Jersey, there's a estate tax if the assets are over $675,000 and not going to the spouse. For the federal government, in the year 2012, it's $5 million. It's unclear what it's going to be in the year 2013. We also ask, basically, who do you want to get your stuff? Most people, spouse 1, children number 2, grandchildren 3, and then who else is going to get it? We draft the documents, we mail it out to the client. Let's see, we make an appointment, the client comes in, and they're asked certain questions. Well, did you read the documents? Does it contain what you want? Let's say, is anyone forcing you to do this? The answer is usually, this is what I want. Yes, it has to be yes, I read it, it's what I want. They sign it, they take the original home, and there's never been a person in 25 years that afterwards says, "Oh geez, I wish I didn't do that," because everyone says, "I'm glad I did that." So therefore, once the will is done, the whole process for what's called probate is easier, because in New Jersey, probate, if there's a will, is very easy. Think of probate as just taking, all that they need to do, the executor, is take the original will, the death certificate, a check for about $150, meet with the county surrogate. Let's see, the county surrogate mails you some papers saying that you're the executor, you're in charge, and then New Jersey to generally leave you alone. So, it's a good idea to have a will done. Let's see, have it done right. Don't rely upon some junk that's online, because those are not New Jersey state specific. Let's see, and again, call a good attorney right away. We have some articles dealing with wills on our website, njlaws.com. That's njlaws.com. Or to schedule an appointment for either a estate planning consult or to go over the probate process, call the law office of Kenneth Vercammen, 732-572-0500. Thank you and good luck. See.
You good, Chip?
You have to say action and then we talk.
Good. Action.
Let's see. Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we look at removing the executor of an estate, let's say, or contesting an estate. Now, New Jersey's a probate easy state. The will is sent to brought to the surrogate, and if someone has reason to challenge the will, then they have a way to file a caveat, but that has to be done before the will is admitted to probate, and there's an 8-day grace period you automatically get after the person dies. What are grounds to challenge the will? Well, the most common ground is not incapacity. It's typically what's called undue influence. And undue influence is where, let's say, someone did a will in the last couple of years of their death, and they changed what would have been their typical way of distributing equally amongst kids, and left everything to the kid that was like nearby. And there's a presumption that if they were living with a child and the child was taking care of their business, that there's some type of undue influence. So if the will is already admitted to probate, then the person who's challenging the will has to have what's called a complaint in order to show cause filed in the Superior Court of New Jersey, in which you're asking that the court put a hold on the probate process and conduct hearings and permit discovery into whether or not there was undue influence in a confidential relationship. Now, sometimes people aren't challenging the will, but what they're doing is they're challenging the way that the executor's handling their business. Well, the duties of the executor basically are to make sure that the bills are paid, figure out what assets there are, file the tax returns, sell, let's say, real estate, and eventually either do an accounting, or if everyone agrees upon their business, have all the beneficiaries sign what's called a release or refunding bond. Sometimes, though, the executor does nothing, or they don't do their job, or they don't answer questions. Well, in my practice as an attorney in New Jersey, what we often do is, rather than just filing a complaint right away, we have the client send a letter or two to the executor. Please provide us with an informal accounting. Let's say if there's an attorney representing the estate, also a letter to that attorney. Let's see. And then if there's no response to that, or the response is not appropriate, then they can hire the attorney to send a letter. Please provide an informal accounting, because filing a complaint order show cause is fairly expensive. Let's say, though, the executor does nothing, then this complaint order show cause is filed to ask the Superior Court to, number one, remove the executor, two, direct that the executor not spend any money, not pay themselves, not pay anyone except mandatory expenses of the estate, let's say insurance bills. If there's a house that hasn't been sold, sell the house. Remove anyone who's in the house that's not paying rent, let's see, and then also compel that person to provide an accounting of all the assets that came in, all the expenses that were made. But attorneys don't do this on a contingency where they don't get paid at the end. So plan on, if you're going to request an attorney to do this, plan on writing a check to them for like $4,000, $5,000, $6,000. Let's say, because again, they don't do that on a contingency. Let's see. Oftentimes, though, once a complaint's filed, sometimes the parties can come to resolution, and any money that's not used up in legal fees, you get back at the end of the case. For other information, we have some articles on website njlaws.com and website benotguilty.com. That's benotguilty.com, or call the law office of Kenneth Vercammen at 732-572-0500. Thank you and good luck.